All right, we've had a panel change. My name is Judge James Edwards. I'll be presiding. Joining me are Judge Jay Cohen and Judge John Harris. If anybody has tuned in to see the case of Arnold Lewis Jones versus Cigna Health, case 19-3269, that oral argument was dispensed with. We are here instead on the case of CTCW Berkshire Club versus CED Capital Holdings, case number 20-957. Both sides will have 20 minutes per side for its argument. We have the clock there, which you should be able to see in one of the panels. When you get into your rebuttal time as appellant, the yellow light will come on. We typically set it at 5 minutes for rebuttal. Like any other amount of time, let me know now and we can adjust that. The 5 minutes, all right?
Yes, Your Honor. This is Steve Griffith on behalf of the appellant. 5 minutes.
Okay, great. Then without any further ado, we will go ahead and get started. Counsel, when you're ready.
Thank you, Your Honor. And may it please the court. My name is Steve Griffith. I represent CTCW Berkshire Club, LLC. CTCW is the appellant in this proceeding, and it is the limited partner of Berkshire Club Partners, a low-income housing tax credit partnership governed by Section 42 of the Tax Code. CED is the general partner, and at issue on appeal is CED's attempt to exercise a right to purchase CTCW's ownership interest in the $23.5 million business. The Circuit Court's order allows CED to acquire CTCW's 99.99% interest for the payment of $1.6 million. The Circuit Court's order via summary judgment should be reversed for 4 reasons. First, the record does not conclusively show that CED exercised its option rights in the form required by the partnership agreement. Second, the record is hopelessly conflicted and disputed when it comes to the price to be paid to CTCW for its interest. Third, the record does not conclusively show that the affirmative defenses pled by CTCW lack merit at this stage. And then finally, the partnership agreement's plain language, which can be interpreted as a matter of law by this court, was interpreted incorrectly by the circuit.
All right. So let's start with it's a contract issue. You have a partnership agreement, and the partnership, the dispute seems really to be which provision of the partnership agreement governs in this circumstance. And so you've got a provision in the partnership agreement that says you get an appraisal and we'll get an appraisal, and we average those appraisals and then we apply a formula. And that's what the judge did. Why is there any factual dispute other than a legal dispute as to which provision of the partnership agreement should be applied in determining the amount paid?
Well, it's our position, Your Honor, that there are 3 separate factual disputes, both as to whether the option was exercised, whether.
All right, let's getting past whether the option was exercised properly. I'm just talking about the valuation.
For the valuation purposes,
the partnership agreement says
absolutely.
You get an appraisal, we get an appraisal, average them, provide and then apply this formula, and that's what occurred.
Absolutely, Judge. And our position is that the circuit court interpreted the partnership agreement incorrectly in that regard.
But that's a legal matter, isn't it?
Absolutely. It's a legal matter on which this court could rule today. And 8.6 of the partnership agreement allows CED to exercise an option to purchase CTCW's interest. 8.6 is very clear. 8.6 says.
But I want to get back to, I just want to make sure that I'm clear then. You don't say that, you acknowledge that there is no factual dispute that if the one partnership provision that says you pick it, you appraise it, we average them and then apply a formula, that there are no factual disputes as to that. It's a legal dispute as to the methodology then, or the parts of the partnership agreement that should govern the valuation, correct?
Correct, Your Honor.
Okay, go ahead.
Yes. And so as a matter of law, when the court looks at 8.6, it provides that the limited partner receives all of the money to which it would be entitled if the property were sold under 4.2. And so the first step is 4.2. And notably, the partnership agreement does not refer to 4.2A or 4.2B, it refers to 4.2. And the very first words of 4.2 say, except as provided in Article 10. It sends the reader to Article 10. Well, Article
Provides
10,
for liquidation and dissolution, and there was no liquidation or dissolution, was there?
correct, Your Honor, there's no actual liquidation or dissolution. And that's the argument that CED makes, is that this is a hypothetical sale, it's not hypothetical liquidation. However, here, as we go through the analysis, there's a lot of things that are hypothetical that are not actually occurring, but we still do. So for instance, the permanent loan is not actually being paid. There's no broker actually being hired. There's not taxes actually being paid. But as part of the formula that's been requested by the partnership agreement, we run through those hypotheticals. And if in fact we were to assume that the property were sold, 10.1 requires that the property be liquidated. There's no ambiguity there. There's no scenario where we would sell the property and not actually liquidate. And so if the property is sold, then 10 requires that there be a liquidation in that instance. And so there's no basis in the partnership agreement to suggest that if the property were sold, we only do some of the things that would occur. We have to do all of those things. And all of those things include, we pay a broker fee, we pay the permanent loan, we pay taxes, but we also would liquidate. And that decision, though, doesn't actually just sit in a vacuum. It exists because of the tax regulations that sit on top of this deal. The partnership agreement is a low-income housing tax credit partnership. It's subject to Section 42 of the tax code, and the tax regulations require that positive capital accounts be returned to partners upon exit. Now, that provision is something that's recognized in the partnership agreement in several places. The partnership agreement affirmatively states that the provisions of 7041B need to be honored. And it actually goes on to state that all provisions of the partnership agreement have to be construed as though 7041B actually controls. Without compliance with those tax laws, this partnership agreement and this deal would not exist. And so in simplest terms, what those rules require is that the partnership keep a scorecard. Every partner has a scorecard regarding its then existing capital investment in the deal. As a partner contributes cash, the scorecard goes up. As the partner gets a distribution or cash back, the scorecard goes down. Now, the importance of the capital account cannot be understated in 7041B or any of the tax rules, but it particularly becomes relevant when we look at the annual filings by CED and the importance of liquidation. Under 7041B, when a party's or a partner's, interest is liquidated, the regulations are quite clear. In all cases, distributions such must be made in accordance with the positive capital accounts of the parties. Now, we've cited authority to the court regarding the validity of those regulations and what they mean and the need for substantial economic effect for those capital accounts. CED has not cited any to support their position that the capital accounts can simply be ignored. The only thing they've cited is some language in 7041B that says that the parties can negotiate away some of the capital accounts. But there are several reasons why that argument's misplaced. First, there is no court that has actually agreed with CED on that issue. This court would be the first to ever reach that decision as it relates to US tax law. Second, more fundamentally, the language of the exception upon which CED relies specifically says that it has to be an arm's length negotiation at the time the agreement is entered. Here, recall, CED even says that the contracted issue here on which they can actually pursue enforcement is the transfer of interest, and it arose in February of 2018.
But the trial court really didn't address the tax consequences, did it?
It did not. It did not address them at all. And that's one of the reasons why we believe the trial court was in error. And the court, though, did order us to sign a new agreement. I mean, that was actually the circuit court's directive to us, was to sign a new assignment. And at that time, there was no arm's length negotiation regarding the capital account. Now, even if we were to assume that a construction of 7041B would allow the parties to disregard the importance of the capital accounts, though, that would require us to read out of the partnership agreement several key provisions. There are entire provisions such as Article 3 that talk about the allocations of gains and losses and how important they are. Provisions like 2.5 that require the maintenance of the capital accounts. Provisions like 10.2 and even 3.2M specifically as it relates to allocations of gain on sale. All of those provisions would have to be read out of the agreement entirely if we are to assume that the parties agreed 15, 18 years ago that they were going to disregard capital accounts. The other thing that's important, and the reason why CED's argument fails in this regard, is that if the parties had agreed in 2002 that they would disregard the capital accounts, then every tax return filed under oath, under penalty of perjury to the IRS since then would be invalid. Because the capital account balance is not simply a number that sits on a spreadsheet in an accountant's office. If the court looks at the K1s in this case, they're on 1049 of the record, you'll see that the capital account balance, the scorecard tally, is always reported to the IRS on an annual basis because the IRS knows that at some point, that particular partner may leave the partnership. And when they leave that partnership, there's an expectation that, in fact, there will be a taxable gain or a taxable loss, that there will be actually cash that is paid if, in fact, there's an exit. And that's what the regulations require, that in all cases, the positive capital account be honored and that, in fact, the capital accounts get restored. Now, the concept that there would be a hypothetical sale where there would just be a write-off of the tax, of the capital account, forgive me, which is CED's position, is nowhere in the agreement at all. The entire agreement is almost 100 pages. It's meticulously negotiated, and nowhere in it does it say anywhere that upon a limited partner's exit, that in fact we are to allocate a fictitious loss of $5 million, or we're to simply ignore the positive capital accounts. 10.2D actually says the opposite of that. It says that if the capital account is positive, then you have to return it. And the simplest way actually for the court to resolve this issue without having to deal with 704 is to say that the statute is that the partnership agreement actually contemplates that there be a return of capital, because that's the language that's in there. It only becomes more difficult, and it only begs the question of how we do 704(1)B if the court decides that positive capital accounts don't have to be resolved. Because under 8.6, we go straight to 4.2. 4.2 directs us to consider Article 10, which says if we have a sale, if the property were sold, which is the language out of 8.6, by the way, we have to go through the liquidation analysis, and that requires the return of a positive capital account. Now, that all assumes, and Judge Cohen, you're correct, that's a legal issue, a pure legal issue. This case comes to this court in the posture of a summary judgment ruling, though, and there are a litany of factual disputes that are in the circuit court record and this summary judgment record. For instance, on price, there are 4 different places when it comes to price where the court can find conflicting numbers. Page 1054 of the record has CTCW's price of $5.3 million. Page 1062 has the partnership accountant's actual calculation. Cohn-Resnick, one of the leaders in this industry, calculated that the price should be $5.3 million. We have another calculation from Novogradac, which is the other industry leader. It says it's $5.4 million, the difference only being the passage of time. And the only place that CED can point to support its $1.6 million is in the record where Brian Spear says that's what it ought to be based on a pre-suit negotiation between the parties where Brian Spear and Mary Stoddard were exchanging figures. That's $1.6 million. Now, if I were weighing evidence, I would say you toss out the parties' interpretations and you look at the industry experts and they say it's $5.3 million. But in summary judgment, in that—
Who do those industry experts work for?
Well,
isn't that in the record?
So Cohn-Resnick was, yes, it is, Your Honor. Cohn-Resnick was hired by CED to be the partnership's accountant. Now, that specific analysis was something that—
Who do they work for as of the time of the summary judgment? Don't both of those industry experts work for the manager of your client?
So after yes, Your Honor. After Cohn-Resnick did this analysis, CED, and the record's unclear on the date, but CED has since fired Cohn-Resnick, and CED no longer does business with Cohn-Resnick. But Cohn-Resnick had been the partnership's accountant for years, and then it does this analysis. It no longer is the accountant for CED. Novogradac, is the expert that was tendered by us to the court, and it also agreed with that analysis. And notably, Cohn-Resnick's analysis actually does occur under 4.2. And Mr. Davenport will tell you that he thinks that the analysis is improper. He thinks it was improperly influenced, but those are credibility determinations. Those are factual disputes.
There was some issue about whether those numbers were actually in the summary judgment evidence that the trial court was reviewing. Can you just respond to that quickly?
Sure. So there's no dispute that the Cohn-Resnick figures of 5.3 million were in the summary judgment record. Charlie Ruda was the expert that we submitted to the court pursuant to the court's deadlines. That was something that was not originally submitted to the court as part of the summary judgment record because it did not exist. And literally the day that it existed, we not only sent it to opposing counsel, we sent it to the court. And I'm highly aware of the need to have a record that is perfected and controlled and what was before the trial court. I will tell you, though, that the Charlie Ruda analysis was provided to the district court, the circuit court, before the court ruled. But the summary judgment hearing had already taken place. Now, even without Charlie Ruda's expert testimony, there's still the evidence from Cohn-Resnick, there's still the evidence from CTCW, there's still the evidence from Brian Spear. You have different calculations in the record which make a resolution via summary judgment not possible given the high standards in Florida. And that's probably where we need to focus a little bit as well. And I see him in the rebuttal, so I'll make that brief. But we are here on summary judgment where CED has to show that it's conclusively going to win the case, where there's not even the slightest doubt that there's evidence in the record that could go the other way. We have evidence in this record that disputes on price, evidence in this record that disputes on notice, same thing on affirmative defenses. And so respectfully, Your Honors, I'll reserve my time for rebuttal and request that the circuit court that this court reverse the circuit court and remand for further proceedings.
All right, thank you very much. Mr. Davenport, whenever you're ready.
Hello, may it please the court. Thank you for having us here today. And I'll try to focus in initially on some of the questions. Specifically, Justice Cohen, I think you hit the nail on the head.
I'm sorry, did you just promote me?
I have. I apologize, Judge.
All right.
I don't believe I have that authority, but so
thank goodness.
You hit the nail on the head. I mean, this is a contract dispute. This is a contract dispute involving a LIHTC agreement in the Low-Income Housing Tax Credit Partnership. These contract disputes are brewing all over the country right now because of individual organizations out there that have come into our industry, and they're known as aggregators. Hunt Capital Partners is coming in and trying to create a fictitious dispute to drive up the costs for my clients and others to try to extort, in this case, more than $5 million of value out of a project that they have no right to. They invested nothing in this deal. They are not a tax credit investor. They are an aggregator, and there's authority that's been offered to provide you with that context so that you understand what predatory activity is happening in our industry, trading on a federally subsidized affordable housing program. And so when you hear arguments like, well, the tax code requires it, 704B, you would be the first court. Wrong. The tax code does not require it. 704B is clear. When you look at the substantial economic effect doctrine, it's out there. It has been complied with. It was evaluated based on the four corners of this partnership agreement when the partnership was formed, and a tax lawyer came in and said, this is all good. It complies with the code, including the exception. And we cite to that, despite what you just heard, at page 42 of our brief. And it's an exception to the substantial economic effect doctrine that says you can have an agreement between parties in an arm's length transaction that can allow for a purchase option like we have here. And that doesn't need to address this substantial economic effect, isolated event, narrow focus that totally reads the tax code out of context and totally changes the economic agreements and sharing agreements of the parties to this deal. And so what you heard counsel say, counsel's quite good. I've been litigating against him quite a bit. He said, well, you need to look at that exception. And he focused on the time of the transfer. And so what they do is they make the time of the transfer, they make the time of the court's order for specific performance the agreement. Well, that can't be the case. It makes the statutory exception totally illusory. It looks like you have a question, Judge. I'm sorry. Okay.
No, he was just scratching his nose. Judge Harris, stop scratching your nose, please.
So Yeah, the exception applies. It applies fully here, and it ought not be read out of our agreement. And why?
Counsel,
why
let's
not?
talk real quick, if you will. Will you address the supposed factual issues about the different purchase prices or option exercise prices that were before the trial court?
Yes, Your Honor, and you're correct. They are supposed difference. They are not actual material, genuine, authentic, or any type of dispute as counsel would have suggested. The first number that he offered, the $5.3 million, is the number that his client posits based on a wrong interpretation of the partnership agreement. As Judge Cohen talked about, this is a real simple case. Section 8.6 talks about get appraisals, get a number, apply a formula. What does the contract say? Go to section 4.2. That's what we did. It's $1.6 million. What they did is they went to that and said, we're going to skip over that and make everything a liquidation. That's why they got their $5.3 million. Then they come in and say, oh, the partnership's accountants, it's Cohn-Resnick. Well, I'm disappointed to hear that narrative still continues, because just about a week and a half ago, Judge Jordan issued his order on damages. And Judge Jordan's order is found on Westlaw now at 20.
If it's not part of this record, you can't argue it here.
Okay, thank you, Your Honor. So what we have before the court as it relates to the Cohn-Resnick is in Appendix 2236 through 2240. And this is testimony from Mr. Griffin's client, Ms. Mary Stoddard, where she acknowledges that there is absolutely nothing in the pricing of this investment for the former investor that assumes a return of a positive capital account. But that's what they did. And then when they went to Cohn-Resnick, they told Cohn-Resnick what to assume. They told Cohn-Resnick that they ought assume exactly what CTCW wants for purposes of the purchase price. So when you look at the record, and I'll get the site for you in just a second, you'll see in that Cohn-Resnick analysis, there are assumptions and footnotes on the very last page. And they say, we used what was provided to us. We were told by CTCW what analysis and what assumption to use. They ran the numbers, which then not surprisingly results in them coming up with the same $5.3 million number that Mr. Griffin just articulated. And their number is immaterial, cannot create a genuine issue of material fact because it's based on a flawed interpretation of the party's contract. It doesn't apply section 4.2. It assumes a liquidation to get to Mr. Griffin's client's number of 5.3.
Didn't Mr. Spear then go back and ask them to recalculate that number based on different assumptions?
He did, and they wouldn't do it. They told him we're out. They sent an email and they said, you know what, we just ran the numbers. We're not getting involved. Deal with Ms. Stoddard. See you later. We're gone. And I think it might have been, well, that would be speculative on my part, but I won't go there. At the time they did it, they were the partnership's accountants. They were the approved accountants by the investor limited partner, and that's who Mr. Spear was working with. And when Mr.
Spear terminated that relationship because because he didn't get the number that he wanted. And that's a claim default of the partnership agreement, right?
That's a claim default that Judge Jordan correctly found was baseless and intended to deprive my client of its purchase option right. And so it had no factual support at all and was deemed to be baseless. And Mr. Spear, as the record would indicate, terminated the relationship with Cohn-Resnick because they had a hopeful conflict of interest and they attempted to persuade him unknowingly, but thankfully he looked at the footnote. Thankfully, he looked at the assumption. Cohn-Resnick never should have got involved. Cohn-Resnick never should have been trying to interpret the parties' contracts. Cohn-Resnick never should have been doing what CTCW told them to do. They should have stayed out. And when Mr. Spear called them on it, they stayed out and they left. But again, that number that Cohn-Resnick provided is immaterial and cannot create a genuine issue of material fact because it's based on an underlying flawed interpretation of the parties' contract. So everything comes back to what Judge Cohen said. This is a contract dispute. This is a very narrowly focused dispute on how to interpret the parties' contract. 8.6 does a very nice job of specifically telling us to go to section 4.2 when you model the hypothetical sale, assume the sale occurs, get to the bottom and do the splits. They're 90-10 now, whereas in the agreement they're 80-20, but they were amended pursuant to an amendment to the partnership agreement. And everybody agrees that CTCW is to get as a proxy for this hypothetical sale 10% of those hypothetical sale proceeds. And so that's it. It's simple. And it should be simple because it accomplishes the goals of the original investor who came into this deal and contributed about $14.5 million as a tax credit investment in order to receive the allocation of tax credits at roughly $14 million, plus some additional losses and some other modest benefits. And how do we know that they did not anticipate any return of a positive capital account balance like they contend now that they're controlled by the aggregator Hunt Capital Partners? At CTCW 00572 in our appendix, we have the original financial forecasts that the original investor, KeyBank, looked at in terms of making their investment for the tax credit benefits. And there's a line item in there about return of capital, yes, no. And they run 4 different scenarios. And in every single instance, they check no. No, 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 no. 4 times under each scenario, no expectation of residual value. And the reason for that is simple. They weren't buying that. It's the antithesis of a tax credit investment. If you're a tax credit investor with large annual predictable income tax like KeyBank is and was, you don't want that. You want the tax benefits. If they were buying residual, the price would have been different. And how do we know they're not supposed to get a return of their capital? Section 2.4 of the partnership agreement tells us no partner shall have the right to demand a return of a capital contribution. That's what they're doing now that they're controlled by somebody else. So when Mr. Griffin encourages this court to interpret the partnership agreement to require a positive capital account be returned, he is asking the court to do exactly what Section 2.4 says they can't do. Now, as it relates to the alleged tax consequences, we've cited to the court a decision from the United States Court of Appeals in the 11th Circuit. It's July 8th, 2016. The Peterson case, 827 F3rd 968, 2016. Again, it's real simple. If you strike a deal, if you put your affairs in order and you line up your businesses and you line up whatever it is you're going to do with your life and you make plans, and it turns out that you have tax consequences as a result of the agreements you make, that's your deal. You can't come in later and try to unwind it. In particular, CTCW can't do it. They're the predecessor to the people that made the deal. So they're trying to essentially say, well, we don't like the tax deal that our predecessor investor made, so will you change it for us? We would encourage the court not to do that because it would violate fundamental principles, not only of IRS case law, but just equity, just fairness, just common sense. And we're all here seeking equity. And in this contract interpretation case, it couldn't be more clear. It's a non-jury because of the way the partnership agreement is structured. Everything will be a bench trial. The judge didn't make any credibility determinations. And when the judge looked at the quote unquote conflicting numbers, the only ones he had in front of him were 2 numbers. And they were the same numbers, and they were the numbers offered by CTCW and Cohn Resnick, who was working on their behalf. And they can't create a genuine issue for material fact to dispute the 1.6 million because the only number offered that assumed a hypothetical sale and a distribution of proceeds under the sale provision waterfall was the one that Mr. Spear provided through CED, which produced the $1.6 million number.
If you can for a minute, Mr. Griffin didn't get much of a chance to get to it, but about the notice requirement and the difference between compliance and substantial compliance and what was done. You would acknowledge in this case, your client did not strictly comply when he exercised his option, right, with the notice requirement?
Yes, Your Honor, I will. And it's quite clear, the leading case in Florida is the Patry case, 633 Southern 2nd, number 9, strict compliance.
That's a statutory case. Most of the cases cited deal with statutes. This is a contract. Aren't the parties free to contract any kind of notice requirement? If I put in there, I want notice given to me handwritten with a red Sharpie stuck under my windshield. You agree to that? Do you have to strictly comply, or can you just email me notice?
I can just email you notice under Florida law, Your Honor, because you look at as
Mega Center case.
The Mega Center case, yes, Your Honor, which was not a statutory case. It's actual receipt and substantial compliance. What's the purpose? What's the purpose of the notice provision? The purpose is to make sure they understand what it is we're trying to do. We want to exercise our option. We want to engage in them. We want to get an appraisal process going, and we want them to participate. The first thing we need them to do is agree to an appraiser. If we won't, fine, go get your own. So there was substantial compliance. There was actual notice, and it's form over substance. In addition to the Mega Center case, Your Honor, I believe the Tim Hortons case does a nice job of outlining that as well, and that's also cited in our brief.
You also argue, maybe the judge found that there was no prejudice as a result of the substantial compliance. Is that a factual determination?
I believe it would be a factual determination, Your Honor, if there was substantial compliance and there were no genuine issues of material fact in dispute that there was substantial compliance. And if there was any prejudice, they would have had an opportunity to articulate some to maybe create some sort of fact dispute, but they can't articulate any prejudice to create a fact dispute because they suffered no prejudice. They participated in the process. They participated in the process by getting an appraisal, and then we came to the average of $23.5 million. So, you know, the other thing that kind of comes into play here is under the Doolittle case, 332 Southern 2nd 107, when we exercised our option, we created a binding bilateral contract. And so they had to participate, and they did participate. And to come back now and to claim form over substances, with all due respect, what we've come to see is commonplace in our industry with the aggregator tactics. So just flipping through my notes here, we've talked about the contract interpretation. We've talked about the fact that there really were no experts offered to the trial court. And quite frankly, this isn't an expert-driven case. This is a case that turns on contract interpretation, and the experts can't tell Judge Jordan or this court or any other judge in the state of Florida or elsewhere how to interpret a contract. And that's what they're trying to do. You know, in terms of the tax consequences, we touched on that with the Peterson case. I see I have more time, but, you know, quite frankly, I think Judge Jordan did such a nice job with the factual record that he has and the legal conclusions that he made. Unless you had any more questions for me, I don't have anything else, Your Honors.
Questions? No? All right. Thank you.
Thank you.
Mr. Griffith, you're back up and you've got 4 minutes and 13 seconds.
Thank you, Your Honor. Let's start with Cohn-Resnick. I heard opposing counsel say that Cohn-Resnick refused to revisit its analysis. That's actually not true. Page 1175 of the record has the email correspondence from Cohn-Resnick that says, we've spoken to several people internally. We believe our initial read of the partnership agreement and calculation that's been shared and discussed is a correct interpretation. Judge Harris, you're correct about the fact that Cohn-Resnick no longer does any work for CED. Second, there was argument regarding evidence of whether or not Hunt Capital Partners is an aggregator and is some bad actor here in connection with the investment. None of that's in this record. None of it at all. It's all a red herring. It has nothing to do with the possible interpretation of the partnership agreement. The partnership agreement itself is clear. It says to go to 4.2. The language of 4.2 could not be clearer. It begins, the very first word is, except as otherwise provided in Article 10 regarding liquidation. It would be impossible to run through the analysis and not see that language and get directed to Article 10, which says if the property is sold, in every instance, not many instances, not lots of instances, not most instances, but in every instance, if the property is sold, there is a liquidation that occurs. The projections that were referred to by opposing counsel, those are not part of the partnership agreement. In fact, if your honors actually look, there are some projections that are attached. They're at pages 515 to 527 of the partnership agreement. There's no projections regarding residual value. There's no projections regarding the return of capital. Those are only projections regarding operations. There are different projections that CED has offered in this particular case and made some claims about who authored them and what the expectations were, but there's no evidence that's competent under summary judgment to say that there was an expectation from the limited partner that it would not receive capital. And even if there were, it's a factual determination. That's the issue here. It would still be a factual determination. I heard from opposing counsel that section 2.4 says you cannot have a return of capital. Of course, 2.4C says you can't get your capital back except with cash. And then in 10.4, it says you can demand your capital back. And you demand it when you leave the partnership, when your interest is liquidated. That's when you get your positive capital account back. That language is unambiguous in 10.4. It's unambiguous in 10.3. And so if we are to actually give effect to all of the provisions of the partnership agreement, the capital account gets returned just as the two industry leading experts say. The concept of the notice requirement, I heard for the first time today, we did see it in the briefs that CED acknowledges that it did not comply. And I appreciate that concession, but there are no factual findings in this record regarding, or pardon me, there are no findings at all from the lower court regarding whether or not there was substantial compliance because that issue was never raised. And Judge Harris, I do think that there has to be a red Sharpie that's delivered along with the notice. And I don't think
Even though you've participated in the process, you can go back now and suggest otherwise? I mean, that makes no sense.
Well, I would agree with that, except, Your Honor, that's not what the record reflects. Because under 8.6, it's the general partner that runs that process. And recall, in this particular record, in February of 2018, we provide the Cohn-Resnick analysis on page 1054 that says we're entitled to 5.3 million. 2 days later, on page 324, CED says, okay, we're in. We're going to go ahead and exercise our option. And then nothing for 9 months. Nothing at all. In fact, in August, we write a letter to them, and this is on page 1652 of the record, that says, if you still want to proceed, you could use this appraiser, but we don't hire these appraisers. It's all under 8.6. It's all up to CED. And it's only after our correspondence in November on page 803 that says, we think you're defaulting here. And then it's actually on December 7th on page 810 of the record when we actually formally place them in default. Only then does CED respond and say, yes, we're going to proceed. We'll give you $1.6 million. Sign this new agreement. That's when the actual chronology occurs in this record. There may be other factual disputes via trial on the merits, but that's what's actually in this record. I see that I'm out of time.
Thank you very much, counsel. Well briefed, well argued.
Yes, it was.